Hey, welcome back to the channel. I'm Local Black Girl, and this video will be an update on the Romeca Blackmon case. In my previous video, I noted that Quadajah Holly Johnson had a scheduled detention hearing for January 7th. Although court did reconvene on January 7th, they were only there for about 45 minutes because the judge had prior obligations. They weren't able to discuss Quadajah's bond. They scheduled for a continuation on January 8th around 9 a.m. We did, however, learn new details about the charges against Quadajah. In addition to the murder charge, Quadajah now faces 5 new charges. Court filing submitted this week outlines the defense's argument for granting her bond. The motion says prosecutors bear the burden of proving that Quadajah committed first-degree murder and argues that the state has not met their burden. Now I'm going to cover some of what her attorneys are alleging. Quadajah's attorneys continue to argue that she has no prior criminal record, no history of violence, and held a valid license to carry a firearm. They also indicate that she was pregnant at the time of the shooting, which indicates that she was also fearful for the life of her unborn child. Self-defense was previously used as her main defense. Her attorney argued that she was protecting herself and her 6-month-old child. Illinois law does allow the use of force if a person believes there is an imminent threat of harm. They claim the victim, Romeca Blackmon, made threats through phone calls, text messages, and family members. They went on to say that Romeca told Quadajah's grandmother she intended to unalive her, which is what led her to obtain an order of protection prior to the incident on September 8th. Quadajah's attorney argued that there is no evidence of the shooting and that the witness statements conflict. They questioned the credibility of one key witness, noting that the person was wearing noise-canceling headphones at the time. They are seeking her release under home confinement or electronic monitoring. At this time, she remains in custody and is scheduled to return, as I stated earlier, 9 a.m. on Thursday, January 8th.
So one of the things that Ari Williams, who is the attorney for Quadajah Holly Johnson, is pointing out, since Ms. Johnson's last detention hearing, counsel has since had the opportunity to speak with her family, review discovery, and understand more about the case than previously proffered, as well as Mrs. Johnson's background. This new information constitutes a change in circumstance sufficient to warrant a redetermination of Mrs. Johnson's detention status, where this court solely relied on allegations that were made against Mrs. Johnson to initially determine her custody status. This court should reconsider its ruling and order less restrictive means. The state is unable to meet its burden of proving by clear and convincing evidence that the proof is evident and presumption is great that Quadajah Johnson in fact committed this offense. The circumstances and facts of this case do not weigh in favor of any of the factors courts consider when determining whether a defendant poses a real and present threat to the safety of any person. Okay? I went on to highlight, in establishing self-defense, the defendant must show some evidence that unlawful force was threatened against them, the danger of harm was imminent, the defendant was not the aggressor, that she actually believed that a danger existed, force was necessary to avert the danger, and the type and amount of force was necessary, and that her beliefs were reasonable. And then they cite a previous case. What the state has failed to capture and sensationalize throughout the reporting of this case is the reality and truth. The victim had consistently and through various means threatened the use of unlawful force against Ms. Johnson. Ms. Johnson, her closest friends, her family members, all have been subjected to the victim's incessant and concerning harassment, whether that be via unsolicited calls or text messages. Johnson was continuously being threatened by the victim on her cell phone to the extent that Ms. Johnson had to block the victim's phone number. The threats from the victim were relentless, even having gone so far as to find Mrs. Johnson's grandmother's phone number, calling her grandmother and making it clear that it was her intent to kill Ms. Johnson. Okay, so here's the portion about the order of protection. So we found an order of protection that was not served. According to them, them being Johnson and her attorney, they have something else. So maybe this is an additional filing. Order of protection against the victim in December 2024. The order of protection was granted July of 2025, a few months prior to the incident. The victim was served with the order of protection, was aware that this order of protection was placed against her. So there you go. That transcript, a copy of transcript for June 18, 2025 hearing regarding the order of protection was tendered to the court. That transcript illustrated the victim's inherent aggression and hostility not only towards Ms. Johnson, but towards the court as well. The court frequently asked the victim to stop and that she was not doing anything to help her case of why Ms. Johnson needs an order against her. Hence, Ms. Johnson has indeed shown and made clear that unlawful force was threatened against her. Further, the danger of harm was imminent where Ms. Johnson reasonably believed that a danger by the victim existed and the use of force was necessary, that the victim presented on the morning of September 8, 2025. After having spent the weekend at the residence of her 6-month-old child's father, who you know to be Carlos Smith. Miss Johnson and Smith drove in Smith's black Mercedes to where Miss Johnson parked her car. Footage captured from the entrance of the school showed the victim heading inside the school building with the son she shared with Smith. This was at 8:51. The victim was then seen exiting the school building at 8:53. At approximately 8:56, Smith's vehicle was captured coming from an alleyway, turning left onto State Street and turning right onto Cermak. Smith's vehicle was double parked 2 car lengths in front of Mrs. Johnson's vehicle facing westbound. In moving her child from the rear seat of Smith's SUV, Miss Johnson placed her child in the back seat of her car. 4 minutes after dropping her son off and exiting the school building at 8:57, a white Kia sedan driving eastbound on Cermak is captured on camera making a U-turn facing westbound on Cermak. The victim owned that Kia. The victim blocked Mrs. Johnson's car by double parking her white Kia on Cermak facing westbound. Now, Miss Johnson and Smith did not invite the victim over. The victim took it upon herself to approach Miss Johnson and Smith in an unsolicited manner, yelling at them, saying, "I told y'all I was going to catch you." Now, that is according to a witness who apparently, and this was also captured on body camera, a witness was saying that Carlos Smith was speaking to officers on scene, and that's what was said, according to him. Carlos Smith, and according to this witness. An argument ensued between Johnson and the victim. Smith noted that Miss Johnson pleaded with the victim to please leave me alone. That's Carlos's narrative of things. Notably, yes, and this is highlighted, I'm not going through all of it. Notably, yes, September 8th, 2025 was the first in-person encounter between Miss Johnson and the victim. However, irrespective of it being the first in-person meeting between Johnson and the victim, the encounter absolutely was enough to cause Johnson to be fearful of what the victim could do to her, especially given the victim's history of violent threats against Miss Johnson. Miss Johnson reasonably believed that the use of force was necessary to avert the danger that the victim was posing to her and her child. The state has also failed to prove, this is according to Johnson's attorney, that Johnson committed the offense when improperly relying on uncorroborated witness statements that is not supported by video evidence. It goes on to say, yet the state is unsuccessful in bringing forth reliable evidence suggesting that Ms. Johnson committed the offense of first-degree murder. Essentially, there is no video evidence at all capturing the shooting, either from the pod camera at the intersection or from bus footage. Witnesses 2, 3, and 4 are all independent of each other. None of the witnesses observed the events of September 8th in its completion, and their statements are entirely inconsistent. And then they question, because that person had on their headphones, what they actually heard. They say that this witness is wearing large, thick headphones over the head. Such headphones will make it impossible to hear exactly what was being said, when other witnesses that did not have on headphones were unable to hear exactly what was being said. All the evidence presented to potentially incriminate Ms. Johnson is circumstantial and cannot meet the state's burden. Where the state fails to meet its burden of proving by clear and convincing evidence that the proof is evident and presumption is great, Ms. Johnson, in fact, committed the offenses she is being charged with. This court should release Ms. Johnson from pretrial detention. And so it goes on to say, it talks about the shots, inconsistencies with if there was a pause in between the shots or not. We also learned that, according to this, Ms. Johnson was about to begin dental school and that she had a successful lash business, according to this. She is not someone who is at risk of repeating this offense against any of the witnesses, nor the community at large. Ms. Johnson is not a threat, this is according to these documents, of any person or the community, and the state will not be able to show by clear and convincing evidence that Ms. Johnson poses a threat to the safety to any person or persons based on the articulable facts of this case. So it goes on to say that, in fact, given that the 31-year-old mom has no background, this is the quote here, of a violent criminal history, Ms. Johnson, and then they cite a previous case, has been continuously employed up to the date of her arrest in December of 2025. She has given back to her community. Ms. Johnson was also given a level 3 in her PSA score, where detention was not recommended by pretrial in this new system. They go on to ask Ms. Johnson could be placed on home supervision or electronic monitoring. Placing Ms. Johnson on electronic monitoring or home detention would allow the court to inspect, direct, and evaluate Ms. Johnson's compliance with the terms of her bond conditions. So that is what they're asking for.
Now it is up to the judge whether Quadajah will be granted bond. I do find it interesting that the defense keeps pushing the fact that Quadajah is pregnant. It's a lot of pregnant women in custody right now. They're accommodated within reason because, let's be clear, pregnancy is not a disability, nor should it be an excuse for a person to escape repercussions of their actions. In my previous video, I did discuss the issue of safety, as there was a fight between members of Romeca's family and the father of both women's children, Carlos. It does look like the courts did take that into consideration, as there were more police presence at the courthouse. It's also been alleged that officers escorted family members to their vehicles after the hearing, which is obviously a good thing due to what happened previously. With them putting these preventive measures into place, hopefully it will prevent another repeat of the last hearing. We'll see how things play out, guys. I'll be back, if not later today, then tomorrow, with my reaction as well as details from today's hearing. I want to thank you guys for watching. Please share your thoughts below in the comments and we'll discuss them. See you guys in the next video.